Sa ngalan samahan, sa anak, sa Diyos Espiritu Santo. Amen. Ginoo, ipadalangin mong Espiritu aron sa paglamdag sa among alimpatakan. Unta dali na mo makatunan ug masabtan ang leksyon nga among pagahisgutan. Ginoo, ikaw ang tuburan sa kaalam, ang pinakagamhanan sa tanan. Aniya kami aron naghangyo nga among matagamtaman ang danag sa Espiritu nga balaan. Aron among makatunan kun unsay sakto ug angayan. Ug salamat sa imong paggiya sa among lecturer nga si Attorney Josephus Jimenez. Maayo unta, tigani mo siya og kabaskog sa panglawas aron mapadayon niya ang iyang advokasya sa pagpaambit sa iyang kaalam sa uban. Ginoo, sa pagtapos sa among lecture, unta among mapuy-an ug hinumduman ang among nakatunan dinhi ug sa among panimalay. Dasiga kami sa pagpadayong sa pagkat-on sa mga butang nga maanindot ug mabulukon. Kinamong gipangayod sa Dios Espiritu Santo. Amen. Sa ngalan samahan, sa anak, sa Dios Espiritu Santo. Amen.
Okay.
Dagan kayong salamat, Emeline. Ug karon aron ni-introduce ang ato ang resource speaker, akong tawgon si Mr. Dan Oliver Carion.
Good evening to each and one of us. Our resource speaker has a solid corporate experience in leading and managing human capital and organizations such as Global Beverage Company or Pepsi-Cola as Vice President for Human Resource and Legal and Corporate Affairs for 5 years. He is also a Director for Employee and Labor Relations and Director for Labor and Industrial Relations Litigation at San Miguel Corporation for 12 years. He is also a HR and ER Director of the biggest Philippine oil and energy and shipping transportation conglomerate or Petron or Petrofil. He is also a former consultant to various business organizations which deals in oil, food, transport, hotels, banks, and other leading businesses. He has extensive mastery of human resources and labor laws as professor of laws in various schools such as University of Santo Tomas, University of the East, Far Eastern University, and others. And he is also a resource person in PMPP, UP Soler, Chamber of Commerce, and other professional and industry groups for over 30 years. He authors books on employee discipline, Philippine labor standards, Philippine labor relations, insightful and helpful to law students, professors, and members of the bar and bench. He's a much sought after resource person and inspirational speaker. Ladies and gentlemen, a true Visayanyan, former Dole Undersecretary Josephus Birondo Jimenez. Sir?
Thank you, Mr. Carion.
You're welcome, sir.
Kuyawan sa imong mga introduction.
Salamat, sir.
Manday na ika-18 ng session na to. This is the 18th session. We started on June 1 and today is the 28th of September. Today is the Bisperas of Argao, Cebu, and tomorrow is the Fiesta of Saint Michael, the Archangel, which in Argao where I was born. So, if there are Argawanons listening today, happy Fiesta to all of you, especially to the Mayor and to Congressman Willie Caminero, my good friend. Okay, today, after discussing unionism and collective bargaining, and also tackling unfair labor practice, we are going to discuss one of the most exciting topics in labor relations, which is about strikes. And in discussing strikes, we have to go back to the Constitution because the Philippines is the only country in the whole world where the right to strike is enshrined in the Constitution. Not even the United States of America, which is the bastion of liberty and civil rights, has a provision of the right to strike in the Constitution. It's only the Philippines. Because of the sad experience under martial law, when the Constitutional Commission of 1987 was convened with retired Justice Cecilia Munoz Palma as the president, and we have two delegates from Cebu. One is the retired Chief Justice Davide, and that is representing the South, and the late Regalado Maambong, who is from the North. So we had Hilario G. Davide from Argao, and from, I think, the municipality or city of Bugo, the late Regalado Maambong. They were part of the 50 commissioners who framed the 1987 Constitution. And most of the provisions about labor were authored by Blas Opley, who was one of the commissioners, and those with about social justice was authored by Chief Justice Davide. So if you look at Article 13, Section 3 of the Constitution, the right to strike is granted, but with three conditions. One is that it must be peaceful, and second, it must be done in accordance with law. The third requirement, which is it should be consistent with national interest, is an addition not by the Constitution but by law. So we will discuss this one by one, and we will do that later when we go into the cases. If you look at the requirements of a strike, to exercise the right to strike, there must be an assurance that it should be peaceful. So once there is an act, an illegal act like intimidation, coercion, any forms of violence, that act will make the strike illegal. Even if the strike started as a legal strike, the commission of an illegal act, which is a prohibited activity. And remember, gentlemen and ladies, that if it is a prohibited activity, it is a malum prohibitum. And therefore, if it is a malum prohibitum, good faith is not a defense. And it is not necessary that there is willful intent. As long as you commit the act, just like in the case of illegal recruitment, when there are prohibited activities, and I give you a mnemonic device for them. Here also, in case of strike, the moment a striker commits an illegal act, so example of illegal acts, vandalism, destruction of company property, libel, oral defamation, grave threats, coercion, and other felonies, physical injuries, and malicious mischief. These are illegal acts, and if they are committed while the strike is ongoing, that makes the strike illegal. And you will know later on what are the consequences of an illegal strike. And there must be no obstruction of ingress and egress. In other words, if there are employees or managers or supervisors who want to report for work, the strikers should not prevent their entry. They should be allowed to enter. If it is a bank, for instance, or a department store, and there are customers who want to enter, the strikers should not form a barricade to the extent of preventing people from going in and also preventing people from going out, from coming out. So the prevention of an ingress or an egress and the barricades in a public thoroughfare, for instance, if there's a strike along Colon Street, Cebu City, if there are big boulders of rock or big trunk of giant trees that are placed in the sidewalk, it is obstructing the public thoroughfare. That by itself will make the strike illegal because that is a violation of the first requirement, which is peaceful. And the most important is when there is a return to work order or the Secretary of Labor has assumed jurisdiction over a labor dispute that is causing a strike, and the strikers, despite having been informed or notified of the assumption order, continued the strike and refused to return to work, the act of defiance is by itself an illegal act. It is a prohibited act and it makes the strike illegal. So there are so many ways by which a strike will become illegal. First of all, is it based on the legal ground? In other words, there are only two grounds: the political ground, which is unfair labor practice, or the economic ground, which is the deadlock in collective bargaining. Union busting is also an unfair labor practice. So if it is not based on this, for instance, if there is illegal dismissal or non-payment of salary, that is not a proper ground for strike because it is not a deadlock or it is not an unfair labor practice. There are illegal dismissals that are also tantamount to unfair labor practice if it involves dismissal of union officers or mass layoff of union members. The union members are targeted by management. That could be classified as unfair labor practice. And then the second under the number 2 requirements of it should be done in accordance with law. So even if your purpose is legal, if the means that you use is illegal, the end does not justify the means. Even if you say, we are really victims of unfair labor practice, so we have the right to strike. Yes, you have the right to strike because you have a right purpose, objective. But the means that you use should be legal also. Because if the means is illegal, even if the objective or the goal is legal, it makes the strike illegal. So you have to memorize these requirements under the Constitution, because if you are asked to decide whether a strike is legal or illegal, then you can decide based on the provision of the Constitution. If you are asked, is the strike illegal? You should state, based on the provision of Article 13, Section 3 of the Constitution, a strike to be legal must be peaceful, and it must be done in accordance with law, period. In the case at bar, it is clear that the strike was not done in accordance with law and it was not peaceful. Therefore, the examinee submits that the strike was illegal. So, again, you use the syllogism. There is a provision of law. There is a statement of the facts, and there is a conclusion. It must be staged by the legitimate labor union. Or one thing I want to remind you, employees and workers cannot strike. Only unions can strike. So if there is no union in a company, even if the workers have been victimized of unfair labor practice, they cannot legally strike, because the formation of a union is a condition sine qua non to the staging of a legal strike. Because under the law, only a legitimate labor union can file a notice of strike based on unfair labor practice. And if there is a deadlock, only the union that has been certified as the exclusive bargaining agent can strike. So there is a right way to do the right thing at the right time in the right place for the right reason by the right parties. And the right party here is a union that is legitimate for unfair labor practice. But for deadlock in collective bargaining, it should be legitimate and also that has been chosen as the exclusive bargaining agent. So if there is no one yet has been chosen as the exclusive bargaining agent, nobody can strike based on deadlock. They can only strike based on unfair labor practice if they are already registered as a legitimate labor organization. In the case of Divine Word University, the reason why the Supreme Court declared that the strike was legal is because, first of all, it was based on legal grounds, which is deadlock and unfair labor practice. Second, it was staged by a union that is legitimate. Not only legitimate, the union has been certified as the exclusive bargaining agent. And they followed the legal procedure. What was the legal procedure that they followed? They filed a notice of strike. They filed a notice of strike. They conducted a strike vote, and they submitted the strike vote result to the DOLE 7 days prior to the actual strike. So they have complied with all the requirements. And the third requirement that is imposed by law is that it must be consistent with national interest. So, what do you mean by consistent with national interest? If the company is an educational institution, like the Divine Word University, if the company is an oil company or a transportation company like PAL, national interest demands that the Secretary of Labor, especially if it is a hospital, the Secretary of Labor or even the President of the Philippines can assume jurisdiction over the dispute. Remember the wording of the law. It is not the strike that is subject to assumption. It is the labor dispute that is causing or likely to cause a strike in an industry that is indispensable to national interest. As to what industry is indispensable to national interest, that is addressed to the sound discretion of the DOLE. The law does not enumerate, but usually based on jurisprudence, educational institutions, hospitals, oil industry, transport company, food company, and even San Miguel Corporation, which is a beer company, was declared as indispensable. Not because the nation will die without beer, but because of the number of people that will be adversely affected if there is going to be a long and protracted strike in that company. Even Nestle, you know, when there is an assumption order or a certification order, what is a certification order? It is an order issued by the Secretary of Labor certifying the case to the NLRC. In other words, directing the NLRC to take cognizance of the case, decide the case within 30 days from the time of receipt. With a sense of urgency, decide if the dispute is deadlock, then resolve the deadlock. If the dispute is unfair labor practice, decide whether there was unfair labor practice. That is an order from the Secretary of Dole addressed to the NLRC certifying the case. It's like, you know, when there's a budget or there is a law that is very urgent, the President certifies it to Congress as an urgent legislation, like the Bayanihan 1 and the Bayanihan 2. When there is the word certification, it means there is a sense of urgency, and the Dole has to, the NLRC has to decide it with a sense of speedy and expeditious manner. No? Return to work order, that is the assumption order and the certification order carries with it an return to work order. I, Silvestre Bello III, by virtue of the authority vested upon me by the Labor Code, do hereby assume jurisdiction over the dispute in X company, and accordingly, all strikers are directed to return to work within 48 hours from receipt of this order. And all the employer company is directed to accept all strikers without any distinction. And maintain the status quo ante. What was the conditions prior to the strike? You have, if that employee was working in one department, you cannot transfer him to another department. You have to return him to the status quo before the occurrence of the labor dispute. That is return to work order. Injunction and restraining order can be issued by the NLRC, not the court. The court has no jurisdiction over a labor dispute as decided by the Supreme Court in the case of San Miguel Employees Union PTGWO versus Judge Bersamira, that the civil courts have no business interfering in a labor dispute. It is only the Dole and the NLRC that has or have jurisdiction. Okay? Another is, if there is a pending case involving the same issue, you cannot strike on that because that will constitute multiplicity of suit or splitting the cause of action or forum shopping. You cannot strike if there is another case pending involving the same issue. I'll give you an example. For instance, Mr. Carrion is the union president and he was dismissed by the company illegally. Mr. Carrion filed a case of illegal dismissal, but the union was angry that their union president was dismissed, and they are alleging that it is an unfair labor practice. So aside from the case of illegal dismissal that was already filed by Mr. Carrion, the union filed a case of union busting, ULP, and filed a notice of strike. What will you do? There are two cases now. One is an illegal dismissal case pending before the labor arbiter, and another a notice of strike pending with the National Conciliation and Mediation Board. If you are the counsel of the company, what action would you take? Answer, I would ask for the dismissal of the notice of strike because the pendency of the case involving the same issue makes the strike or the intended strike cannot be done with when there is a pending issue in pending case involving the same issue. Do you follow what I'm saying? Are you following me?
Yes,
So
USEC. Yes,
okay.
USEC.
Because, you know, in the case of Alo versus Mendoza, the Supreme Court said that splitting the cause of action or multiplicity of suits or forum shopping are obnoxious to the orderly administration of justice. Obnoxious to the orderly administration of justice. So you cannot, hindi ka pwedeng mamangka sa dalawang ilog. Hindi ka pwede na mag-litigate sa dalawang forum because a strike is also a form of litigation. You are looking for a solution through concerted action. A strike is really a means to achieve a goal, which is the goal is that all your demands will be granted because you are trying to force the company, and this action is legal. If the company needs your services, the company will finally decide to grant your demand. So a strike, therefore, is not an end by itself. It is a means to achieve an end. So now what happens if there is an illegal strike? No, illegal strike. If you are asked to make a decision, what happens to the employment status of the employees, the union leaders and members, if there is a declaration of illegal strike? Then your answer should be, the examinee makes a distinction, or the examinee begs to distinguish. Letter A, all union officers, by the mere participation, knowing participation, do not forget the word knowingly participate. The officers knowing participation, mere participation by the union official, and also knowingly committing illegal acts. This will make the strike illegal, and that will cause loss of employment status. So hindi na sila kailangang tanggalin pa ng management because by virtue of their own acts, ipso vigori, by virtue of the act. Because if you say ipso facto, that is by virtue of the act. But if you say ipso vigori, by virtue of the act, ipso facto is by virtue of the fact. No? So by virtue of their own acts, they have lost their employment status. So you will not tell them that you are hereby dismissed. You will just tell them that by your own acts, by your own illegal acts, or by knowingly participating in an illegal strike, you being an officer, you have lost your employment status. So you do not have to terminate him because he has already terminated himself. Kailangan mo pa bang barilin yung taong nagpakamatay na? So anong gagawin mo? You just declare that he is dead on arrival. So when I was vice president of Pepsi Cola, I just told the illegal striker that by virtue of your own act, you have lost your employment status. So it is your act and not the management decision that caused the loss of employment status. So since you have decided to lose your employment status, please be informed that the company has no objection to your decision to lose your employment. So we are not saying that we are dismissing him. Because if we dismiss him, then he will file a case of illegal dismissal. But if you say, I did not dismiss you, you have dismissed yourself by your own act. Oh, see? So where will he go to find a relief or remedy for that? But for the union members, mere participation is not enough to lose employment status. It is only the commission of illegal act. So there are really differences between a union member and a union officer. And the meaning of the union officer here, ladies and gentlemen, you have to be very careful. It is the elected union officer, not the appointed. Those whose position are included in the bylaws, in the constitution and bylaws of the union. There are officials that must be elected: president, vice president, secretary, treasurer, auditor. These are the elected. Board of directors, they are elected. But if you are only an assistant treasurer appointed by the president, you cannot claim that you are an officer. You are just a member. And so you have more protection. If you are a member, you have more protection because your mere participation will not cause you to lose your employment. That is clear. We will now start with cases. In this case o bukluran ng mga manggagawa sa Clothman versus Court of Appeals, this involves the definition of a strike. Ladies and gentlemen, you have to know how to define a strike, because a strike is a concerted action, any temporary stoppage of work by concerted action of the employees as a result or in connection with any labor or industrial dispute. Okay? So the elements therefore is that there must be a temporary stoppage of work. If there is no temporary stoppage of work, there is no strike. Even if they will picket, because you can picket without striking. You can also strike without picketing. But the Supreme Court here in this case decided against the union and declared that there really was a strike because there was a temporary stoppage of work and the workers did it in concert. So they were conspiring and confederating with each other. A strike really is a conspiracy. It cannot be committed only by 2 or 3 people. It is the decision of the organization, no? And the cause of this is a pending labor dispute, whether it is a deadlock or an unfair labor practice. It is a dispute that is causing the strike. So that should be clear. What is the similarity between a picket and a strike? You know, picket when you bring the placards and you march around the perimeter, or you are moving. You know, one of the requirements of a picket, it should be a moving picket. That's why the picketers bearing the placards should march or walk back and forth, because once they stay stationary, it makes the picket illegal, because it may result into a barricade that will cause the prevention of ingress and egress. Okay? So if you picket but you are not on strike, how is it done? Suppose we are all employees of a company. Morning, we report for work until 12. At 12 o'clock, we eat our lunch 10 minutes only. After eating our lunch, we rush out into the streets, bear the placards. But at 1 o'clock, we report back to work. You are picketing, but you are not striking. Why? Because you did not, there is no stoppage of work. So that is a picket without a strike. But you can also strike without a picket. If all of you all of the employees or most of the employees stay at home tomorrow and not report for work, there is already a stoppage of work, and it is in connection with a labor dispute, and it is done by the union in concerted action. It is not done by one or two, but a group of people, no, and they are doing that because of a labor dispute. So you should be very clear that a picket is not a necessary element to a strike, that you can strike without picketing, and you can also picket without striking. Now, for a picket, you do not need to file a notice to picket, but for a strike, you have to file an advance notice of strike 15 days before the strike. A picket can just come if the local government unit like the city of Cebu requires permit, that you have to comply with the permit. Otherwise, you will be dispersed by the police force for violating the city ordinance and for disturbing traffic or whatever problem that you are causing to the movement of people in the city. In the case of Association of Independent Unions in the Philippines, et al. Versus NLRC, Justice Purisima, writing for the 3rd Division of the Supreme Court, said that a strike is a legitimate weapon in the universal struggle for existence of the union. It is considered as the most effective weapon. That's why during martial law, that's why they say that there is a repression of civil rights, because strikes were not allowed during martial law. All strikes, all demonstration, all pickets banned under martial law. But when the new labor code was promulgated in 1987, they have elevated the right to strike to a constitutional status. And so here, the Supreme Court itself said that it is the most effective weapon, because if the company really needs the services of the people, they will be forced to give in to the demand just to be able to operate. Because the purpose of a strike is really to paralyze the operation. And that is legitimate objective, to paralyze the operation. As long as you do it in a proper manner and you are legitimate labor organization, the strike is supported by the majority, you have conducted a strike vote, you have submitted the strike vote 7 days prior to the actual strike, you have observed the calling off period, then that is allowed, even if it will result to the paralyzation of the operation of the company. But this right, just like any other rights, are not absolute. This right is not absolute. This right is subject to certain limitations, that the striker should not commit any act of violence, coercion, intimidation. That's why the first requirement is it should be peaceful, and it must be done in accordance with law. You cannot strike, for instance, if the company is located in Colon Street and the owner resides in Guadalupe. You cannot strike in front of the house of the owner. That is not the proper place. That is not the proper strike area. But there's an exception to that. If the company transfers the machinery to another area or has been transferred to another company. For instance, one of you is an owner of a company, and you have a brother who also has a company similar to you. You are operating a rattan factory in Mandaue. The other is in Lapu-Lapu. So when there is a strike in Mandaue, you bring all the raw materials and the facilities and the tools to Lapu-Lapu so that your work will be done in the factory of your brother or sister. That is called a runaway shop. So if there is a runaway shop, the strike can also have a runaway strike. The strike now, the striker will be allowed to transfer their strike to another area because the runaway strike is the balancing mechanism allowed by law when there is a runaway shop. A runaway shop will allow a runaway strike. So even if the strike should be confined in the area where the place of the operation of the company, it can extend to another place if they by itself has transferred the operation to another unit. Are you following me?
Yes, USEC.
Okay. In this case, the Supreme Court said that the right to strike must be exercised within the bounds of law. So the union officers are duty-bound to guide their members to respect the law. But instead of respecting the law, it is the officers that give orders to the members to barricade, to prevent ingress and egress. Then that those officers should answer to the force of law, and they will lose their employment status. In this case, the court finds merit in the finding that the labor arbiter and the NLRC made that the respondent company committed no illegal lockout, because you know the strikers here said that when they were ordered to return to work, they were already willing and ready to return, but it is management who locked them out. So the facts of the case do not indicate that there was a lockout. It was really the workers who voluntarily stopped working, and their being without work could not be blamed on the company if they did not have income. Because my friends, I tell you, although you know this already, I remind you now that during a strike, the principle of no work, no pay shall apply. So even if you have many available leave credit, you cannot say that I will just charge my strike to the leave. No, because it is your decision not to work. You will not receive a pay for that day, because it would be, you are intending to paralyze the company. And so why should we require the company to pay you for services that have not been rendered? So the principle of no work, no pay shall apply. And when the strike is over, you cannot claim back wages. Whether the strike is legal or illegal, it doesn't matter. Since it is the decision of the workers not to work, they cannot claim back wages if there was a delay in reinstating them for one reason or another. That delay should not be blamed on the company, and the company should not be made to pay when there is a strike, which is the decision of the union membership. But in this case also, the Supreme Court said that the NLRC or the Court of Appeals cannot allow mass layoff. Mass layoff meaning all strikers lost their employment. No. First of all, only the union officer. Second, if you want to dismiss a union member, you must have an evidence pinpointing that each one has committed an illegal act. This is not a group fault. In other words, it's not like conspiracy that the act of one is the act of all. No. You have to identify that Mr. A has committed malicious mischief. Mr. B has inflicted physical injury. And there must be a substantial evidence to prove every illegal act and to pinpoint to a specific person. A photograph of the striker bearing a placard is not enough proof that he committed illegal act. There must be a positive testimony and other corroborating evidence to establish the fact that every individual who is sought to be dismissed has committed an illegal act. But those union members, it's not necessary. As long as he was present, the union officer, the mere participation of the union officer knowingly participating shall lose their employment status. So just because you are a striker and the strike has been declared illegal, it does not follow that you lose your employment. First of all, are you an officer or a member? If you are an officer, we have to establish that you knowingly participated. But if you are on leave, and you were not seen, so how can you be dismissed? Your leave was approved by management. So, an employee who is on leave and who has never participated in the strike cannot be included in the termination of employment, because if he is an official, he did not knowingly participate in the illegal strike. He also did not commit an illegal act during a strike. So, this is the case of UST Faculty Union versus Director Bitonio, where Justice Panganiban, later Chief Justice, said that there is a right way to do the right thing at the right time, for the right reason, and in the present case, the right forum by the right party. So, the strike is not the right remedy for other labor disputes, except only on unfair labor practice and deadlock in collective bargaining. So they have to settle their disputes in other fora, in other forum, not strike. The strike is the wrong remedy. It may be true that you are a victim of illegal dismissal or non-payment of your benefits, but the strike is not the proper remedy for that. You can file your case under Article 224 of Book 5 before the labor arbiter. This is one of the most controversial strike. The strike in Hong Kong and Shanghai Banking Corporation. This could be one of the reasons why the bank has decided to stop operating in the Philippines. Because in the year 2016, no, that was the year of the decision. This was very much earlier than that. It was 2 days before Christmas, December 23, that the union staged a strike. They barricaded the Makati and the Ortigas branches of HSBC, and the president of the bank, who was a foreigner, could not go out 3 days before Christmas. The bank has to get a helicopter to extract them from the rooftop because the union were very aggressive, they were very antagonistic, and they were already very violent. And there was already physical injuries in the picket line. So it was very dangerous for you to force your way. So this case, therefore, is one of the example of an illegal strike. But only the union officials were ordered to be dismissed or to have lost their employment status. The Supreme Court ordered the reinstatement of the union members, and a reinstatement is no longer feasible because of strained relationship, then separation pay. Because even if this is the right, it is the right of the workers, but that right has certain boundaries. There are parameters, and the strikers exceeded the bounds. They exceeded the limits of their right. Because even if the objective is the attainment of justice, it is the right to strike is never intended to destroy the company, to destroy the employer. Just to paralyze the operation, not to destroy. A notice of strike was filed with the DOLE, 30 days for deadlock. A strike vote was approved by the majority of the local union membership. A notice of the results of the voting was submitted at least 7 calendar days before the intended strike. Those are the requirements. But in this case of Hong Kong and Shanghai Bank, no strike notice was filed. Can you imagine? They did not file a notice of strike. And there was no observance of calling off period, because where will you begin to count the 15 days or the 30 days if you did not file the notice of strike? No? So the union broke all the rules. And they obstructed the ingress and egress in Makati and Pasig, Ortigas, Pasig. Multiple violations, intimidation, obstruction committed by the strikers. They have resorted to unusual and violent means to gain access to the premises. And the bank officials were trapped inside the bank, and management had to use a helicopter to extract the officials from the premises on the eve of Christmas. 24 na yata. 24 na kasi nag-umpisa 23. The union officials asserted their good faith. But I told you, good faith is not a valid defense when you commit a prohibited act. So the Supreme Court ruled out good faith because they have disregarded the procedural requirements for conducting a valid strike. So they have committed a malum prohibitum. They have committed a prohibited act. Even if the union believed in good faith that the bank was guilty of ULP, good faith is not a valid defense in cases of malum prohibitum. The fact remains that the strikers did not comply with the restrictions prescribed by law. They did not establish evidence of compliance with the procedures of holding a valid and legal strike. Now, after the Hong Kong and Shanghai Bank, let us go back to that strike along Jones Avenue. From the corner of Fidel Rosario in front of the this Visayas State Technical University, or in front of Abiliana, the other side. You walk towards Puente Osmeña. In the right side, there was a hospital called Community Hospital, which is now called the Visayas Community Medical Center. It is owned and operated by the Protestant Church, the United Church of Christ. And this is the church where former Dean Porcia Hormachuelos belongs. She is a certified member of that church. No? And I used to go to the church because I used to have a girlfriend who was a Protestant. So we attended the religious ceremony there. I liked the music, the songs. And after attending the ceremonies in Bradford, that is called Bradford Church, my girlfriend also came with me to San Carlos because there is a mass in the University of San Carlos. I used to be serving there as a reader or a lecturer, lector. So I used to go there. So I hear mass in Protestant. I also hear mass in Catholic. No? But anyway, that hospital, which was operated by the Church of the United Church of Christ, was embroiled in an intra-union dispute. You should always remember that it is illegal to strike based on intramural of the union, because it's unfair. Why do you damage the company when the problem is between one faction of union and another faction? So this is now a problem between a federation which is legitimately registered. The federation which was legitimately registered had a local which is not registered. So the local people form another union, even if it is not yet registered. They have staged a strike. So from the very beginning, it was already illegal ab initio, because the requirement to file a notice of strike is that you must be legitimate labor organization. So this is really a conflict about union dues, conflict about political power. I told you before, there are only two things that will cause our conflict. Dalawang P, pera at power. No, pera at power. Ang pangatlong P, na hindi ko masabi, sasabihin na lang natin na pag-ibig. Tatlong P. Conflict ng mga tao, nag-away sa poder, election case. Nag-away sa pera, magkapatid, nag-aagawa ng mana, collection of money, estafa, kung ano-ano, power, pera, no? Pangatlo, pag-ibig, no? So this one is a conflict about power and pera. So here, the strikers were not registered as a separate union. And the federation with a local chapter did not support them. So this is one faction of the union that had a very long, many months, they were barricading the sidewalk. No? And even those who want to check in as a patient were adversely affected because of the barricade that they conducted. So the Supreme Court saying that any union officer who knowingly participate in an illegal strike may be declared to have lost his employment status. And any union member who knowingly participate in the commission of an illegal act, remember, commission of an illegal act. And so mere participation of a member, even if he knowingly participated, if he is just a member, he will not lose his employment status. No? So, the complainants in the case that reached the Supreme Court, led by Irma Ibalye et al., were mere members, and there was no evidence that they committed illegal act. So this should not be declared to have lost their employment status. But the union leaders who knowingly participated, in fact, they were the ones who started it. They were the ones who instigated it. Then they have to be given a heavier penalty. Because knowing fully well that they are not registered, they proceeded to conduct that strike. So the Supreme Court said that we stress that the law makes a distinction between the union members and the union officers. So again, you should be very careful when you go to the bar exam. The law grants the employer the option. This is the word of the Supreme Court. The law grants the employer the option of declaring a union officer who participated in an illegal strike as having lost his employment. Take note ha, huwag mong sabihin doon sa answer mo that the management or the employer is given by law the right to terminate the employment. No, he does not have to terminate. All he has to do is to declare that the employee, ipso vigore, by virtue of his own act, has lost his employment status. So, management was wrong in terminating all employees, including the mere members. That is mass termination, was illegal. However, since reinstatement was no longer feasible because 15 years have passed, 15 years have passed. Whose fault is it? 15 years have passed. How can you reinstate these people? No? As found by the labor tribunals, the members' mere participation was only wearing armbands. There is no specific evidence pinpointing that they committed illegal acts. While the union officers, it was very clear that they actively participated. They were the ones who instigated and they were the ones who organized. So how can they escape liability? So the Court of Appeals was correct, according to the Supreme Court. The Court of Appeal was correct in declaring that the mere members were illegally dismissed. But the Court of Appeals committed an error in granting them back wages. See? Because it was the strikers who decided not to work. Why should you give them back wages? On the principle of no work, no pay, and the principle of a per day's wage for a per day's work. since it is the striker who decided not to work. So what right do the striker have to demand payment of wages? Can you hear me?
Yes, USEC.
Okay, I'm just checking once in a while. No? So the Supreme Court said that 15 years had lapsed from the onset of the labor dispute. And in view of the strained relations that ensued, in addition to the reality of replacement already hired, so reinstatement has become an impossibility, and separation pay now without back wages is the appropriate remedy. That is for the union members. But for the union officials, they do not receive any separation pay because the loss of employment status was justified by their knowingly participating in an illegal strike. So there are enumerations made by the Supreme Court. When is separation be granted in lieu of reinstatement? So there are 7 there. But some of them are repetitive. When reinstatement can no longer be effected in view of the passage of a long period of time. Number 2, when reinstatement is inimical to the employer's interest. Winilgahan ka na. Sinira pa ang pangalan mo. Nilagay ka pa sa placard, sinunog pa yung effigy mo. Tapos reinstate mo yan. No? Parang boyfriend mo yan eh. Pagkatapos kang inanakan, binuntisan, iniwanan, nilalait ka pa. Tapos ang sinama niya yung kaibigan mong pangit, ikaw sobrang ganda mo. Tapos ibabalik mo pa. I-reinstate mo pa yung kanyang yung tao na gano'n? Oh. Anong klase namang hustisya yung ginagawa mo sa sarili mo? Ginawa mong kawawa ang sarili mo. There is already a strained relationship. You know, I remember I have an uncle who worked in the GSIS. And the wife was also related to us. The uncle, his family name was Jimenez. And, you know, the wife, because of difficulties, financial difficulties, went to the US and arrived there in the US, working there. But she could not get US citizenship. She could not get any permanent residency. So she married a black person. I met that black person. I used to go there when I go to the US. I always visit that favorite auntie of mine. And the uncle here, the wife asked permission that this is just kunwari lang na marriage. This is not really true. No, just to have a citizenship, and she can get all the children. So all the children went to the US, leaving the father and the husband here alone. And then later on, the black person died, the husband. So the wife said that he wants to reconcile with the husband. The husband said no. Yung mataas ang pride yung tiyuhin ko eh, kasi after sa ginawa mo sa akin, so na nakisama ka sa negro, pagkatapos makipagbalikan ka pa sa akin, ayaw na, hanggang namatay siya. Namatay siya, yung maid na lang niya nag-alaga sa kanya. So ganun talaga ang buhay. Ganun din sa strike. Winilgahan mo yung kumpanya, nilalait mo, minumura mo, inaalipusta mo. Pagkatapos, later on, you will ask for reinstatement. So that's why even if you are just a member and you were ordered to be paid separation fee in lieu of reinstatement kasi sobrang asiwa na asiwa. Kung sa Tagalog yan, asiwa. Kung sa Bisaya, bakikaw ba, bakikaw. Murag dili na maayo ba nga after all what happened, hindi na pwedeng ibalik hindi na pwedeng muling buksan ang puso. Kasi sobra nang nadurog ang puso. Kita mo ang ganda ng mga paliwanag ko sa inyo. Di pa ninyo maintindihan yan? Now, I'll tell you about assumption. There are many technical things I want to tell you. First, remember that the party to a strike is a union, not the employees. So this is the technicality. When the union in Nestle ito 1986, after the EDSA Revolution. After the EDSA Revolution, 20 years na nagkaroon ng repression ni Marcos, pagdating ni Tita Cory, ang rights sobrang bumulwak ang right, napasubra naman ang mga tao, pati barbershop nagtayo ng union, no? Kahit maliliit na kumpanya nagtatayo ng union, no? Okay, good afternoon, Miss Michelle Abilia, our HR manager is with us. Good afternoon. Welcome to our bar review. We are happy that you are here today. And you should come here next time because the next topic we will have is about termination of employment. So this all kinds of offenses, management prerogative to hire, fire, transfer, promote, lay off, discipline, and all the kinds of offenses like I will have some offenses involving educational institutions. So many cases involving universities and colleges about faculty members that were dismissed because of gross and habitual neglect of duty, sexual harassment committed against students. So many. I encourage you to be present because even if you are already learned by virtue of the experiences, you know, I have 45 years of experience and you can get from my stock knowledge, no? So I welcome you and I hope that you will come back now. Si Ma'am, wala na mo balik si Ma'am Velasco, no? Si Crispy.
Murag na siya
Ayaw na
meeting
siguro
karon,
niya kasi
attorney.
Maingon si Crispy siguro, strike yan, no? Wala man tayo union din eh. So next time, imbitahin natin kasi termination na pag-usapan natin. I will discuss about sexual harassment cases, about yung LSR ba? LSR. Alam mo ba yung LSR, Attorney Wagas? Ano yung LSR? Love, sex, and romance in the workplace. Love, sex, and romance in the workplace. Abangan ninyo yan kasi
natin yan, Attorney.
very exciting yan. Very
Attorney.
exciting. No? That is doing the right thing with the wrong partner in the wrong place at the wrong time. It's like the right love at the wrong time.
Kanta mo na, USEC?
Oh, it's the right love in the wrong time. And maganda. So ituloy ko ito ha, strike ha. Balik tayo sa strike. Way back in 1986, there was activism in the employment sector. Kaya ako, kinuha ng San Miguel. Alam mo, magpasalamat din ako sa KMU eh. Kasi kung hindi ang KMU, hindi ako makuha ng San Miguel. Naghahanap ang San Miguel ng isang abogado na nakakaintindi ng HR at yung dating aktivista. Sinong iba? Kundi si JBJ. Si JBJ na bilanggo ng 49 days sa Camp Sergio Osmeña na detain sa martial law. Si JBJ ay may 20 years experience sa Department of Labor at hinahanap ng San Miguel ang mga karibal ko sa posisyon, UP, Ateneo, mga mabibigat. Ako, Ateneo de Colon ako eh. So ako ang pinili. Ako ang pinili at inoferan pa ako. Si Mr. Soriano talaga nag-offer ng job ko. Sabi ko, I'm happy with Petron. Why are you going to entice me to transfer to San Miguel? But it is because of the strike. Ngayon, itong Nestle, alam mo yung Nestle was owned by San Miguel before. 49% of the shares of stock of Nestle was owned by San Miguel. 51 by some stockholders plus Switzerland, Nestle Switzerland. That is really the headquarters of Nestle in Switzerland. So, nagkaroon ng wilga sa Nestle. Pagkatapos, ang Secretary of Labor nag-assume ng jurisdiction. Si Frank Drilon na ang Secretary of Labor noon eh. Kasi nung nagkagulo na si Bobet Sanchez, yung aktivista na ginawa nilang Dole Secretary, ang ginawang undersecretary si Frank Drilon. Batang-bata pa si Frank noon eh. Kaya naging senador si Frank eh dahil sa Dole. So si Frank, kinuha nila, si Frank nag-assume ng jurisdiction. If there's a strike in Nestle, the Secretary of Labor assumed jurisdiction over the dispute causing the strike. So that means you have to return to work. All strikers must return to work within 72 hours from receipt of this order. Now, ladies and gentlemen, I tell you, this is the technicality. Since the one that files the notice of strike, Mr. Carion, I remember this, Mr. Carion.
Yes, sir.
The one who filed the notice of strike is the union, not the employee. So, if it is the union that files the notice of strike, the notice that the secretary has assumed jurisdiction shall be served on the union, not on the employees. Now, ngayon, ito ang problema. There are more than 2,000 employees of Nestle. 2,000. Merong planta sa Cagayan de Oro, may planta sa Laguna, may planta sa Bulacan. So lahat na yan nagwelga. Ngayon, the notice of the assumption is served on the headquarters of KMU. KMU sila eh. Napasok ng KMU eh. So now, some of the strikers, alam mo yung mga Pilipino, ayaw naman talagang Pilipino ang gulo eh. Pero pag ang union nagwilga, nakikisama na rin sila. Pero yung iba, hindi nagpapakita. Yung iba umuwi sa Ilocos, yung iba umuwi sa Bicol, yung iba umuwi sa Mindanao. Ngayon, ito, 72 hours to return to work. And the notice was not sent to the employee. It is not the duty of the Secretary of Labor to inform each and every one of the 2,000 employees. Only the union. So the union now should inform the members. Eh yung iba, wala pang cellphone noon eh. Wala pang uso cellphone noon, 1986. Hindi pa masyadong kuha ng cellphone. Walkie-talkie pa, may beeper pa nung araw, beeper eh. Yung ginagamit ng mga doktor eh. So, wala. Maraming hindi naka-return to work. So, ngayon, the issue is this. First issue, why should the Secretary of Labor assume jurisdiction over a company that manufactures coffee? Is coffee indispensable to national interest? Sabi ng KMU ha. In other words, the Secretary of Labor committed grave abuse of discretion in assuming jurisdiction, and this is a violation of our right to strike, which is enshrined in the Constitution. Ganda ng issue nila number 1 eh. Number 2, that the workers is declared to have lost their employment status without prior notice to the worker. That is a violation of due process. And number 3, ito masaya na issue. since the assumption order of the secretary is questioned by the union, and we have raised this matter with the Supreme Court, while the issue is pending with the Supreme Court, we should not be compared order. Are you following me? Kayo naminaw na ko. Can you follow me?
Yes, USEC. Yes, USEC.
Ikaw lang sumasagot eh. Nag-iisa ka lang eh.
Yes, USEC.
Okay.
Yes, you said.
Yes, you said.
Yes, sir.
Loud and clear. Loud and clear.
Ito ha. Ikaw, Mark Alvario. Naminaw ka na ko. Ito yan. Ang sabi ng abogado ng KMU, bakit kami susunod sa order? Kini-question nga namin yung validity ng order pagkatapos susunod kami return to work. Sinabi return to work. Sabi, no, that order is invalid because first of all, this is not indispensable to national interest. Second, we are questioning the validity of the order. Why are we going to comply with the order which we are questioning? So if we will comply, stupil na kami. Sasabihin na ng Supreme Court, mot an academic na ito, comply na kayo eh.
Yes.
Diba?
Yes. Yes, sir.
So ngayon, how did the Supreme Court resolve the issue? Number one issue, is Nestle indispensable to national interest? Ang sabi ng KMU, hindi mamatay ang bansa natin kung walang kape. Ang sabi ng Supreme Court, hindi ganyan ang batayan to determine indispensable to national interest. Wala yan sa produkto. Ang San Miguel nga, beer nga, dineclare nga yan indispensable eh. Sipin lang ninyo yan. So how do you determine indispensability? Ganito, in a period of social conflict and economic crisis, when a company with 2,000 employees is not operating, there are 2,000 families that are not receiving their wage. And there are many suppliers of coffee that are affected, even those that are delivering through that. So many people are affected, including those who are selling the coffee. Everybody is affected. So, because of the magnitude of the scope and the far-reaching consequences of this strike, it becomes indispensable to the interest of the state. In the exercise of police power, the state can assume jurisdiction because the relationship between labor and capital, according to Article 1700 of the Civil Code of the Philippines, the relationship between labor and capital is not merely contractual, but it is imbued with public interest that the state, through the Secretary of Labor, must intervene in order to break the impasse and the deadlock. Yan. Yan ang first issue. Talo ang union.
Yes. Yes.
Second issue. Second issue. Why is the notice sent only to the union, not to the employee? Ito na sinabi ng Supreme Court. Remember that the party to the strike are not the employees, but the union. Who files the notice of strike? It is the union. And so, why should the Secretary of Labor be obligated to notify 2,000 employees when it is the union who filed? So, you, union, it is your obligation to inform your members. It is not the obligation of the state to inform all of them. So your objection is set aside for being lacking in merit. The third objection, while you have filed a petition for certiorari under Rule 65, questioning the so-called abuse of discretion of the Secretary of Labor, you are complaining that you should not comply because if you do, you will be deemed to be in estoppel. The answer of the Supreme Court is this. Return to work order, assumption order, is characterized with a sense of urgency. That even if you are questioning, you will not be in estoppel, because what is important is that you have to comply immediately. You are given only 72 hours to comply. And failing in that, what is the result of failure? You have committed a prohibited act, which is a defiance of a return to work order. And what is the result? You have lost your employment status. You, the union official, you lost the employment status because you refuse willfully and knowingly to comply with a lawful order issued by a duly constituted authority by virtue of a provision of law in the exercise of police power of the state. Can you imagine? All the arguments of the union was demolished by the Supreme Court. So that you should bear in mind that if it is already an assumption order, whether you are right or you are wrong, you have to return because the state is not prejudging your case. Kung ang pinaglaban mo ay unfair labor practice and the Secretary of Labor assumes jurisdiction in your case, it does not mean that he is saying he is already prejudging na hindi tama yung ULP charge mo. No. Ang sinabi lang na Supreme Court, balik muna kayo sa dati, then I will hear and decide your case on the merit. So, for all we know, mananalo kayo if you have all the evidence. But for the meantime, you have to comply. That is the important thing. Compliance, you obey first before you complain. Because if you do not obey, you are defying an order issued by the state in the exercise of police power, and you will have to suffer the consequences of your disobedience. Just like in this case, Magdala case, illegal strike due to commission of prohibited acts. Just the same, just like the case in the community hospital. Slowdowns. Oh, ito, importante ito ha. What is a slowdown? A slowdown is when the employees are reporting for work, but they will not perform their job. They are just sitting down. They do not do their usual duties. And this is more deplorable. It is more despicable. Why? Because you are receiving your salary but you are not performing your job. Mas mabuti pa yung magwilga kayo kasi hindi man kayo pasahurin. Magwilga kayo, that is better. Because the principle is no work, no pay. Itong slowdown, you are reporting for work, nagta-time in ka, nagbabandikla ka, then you demand salary for that day, but you are not doing your work. You are having a sit-down strike. So this is called strike in installment, slow down. And this happened in Monterrey Foods. And you know, Monterrey Foods is also owned by San Miguel. Punta ka sa Tagaytay, sobrang libo-libo ang mga baka. Bakit merong Monterrey, yung mga Monterrey chicken, may Monterrey na mga meat, may mga pork, lahat na yan. San Miguel yan, ang may-ari ng Monterrey. Lahat na yan, covered ko yan. For 12 years, covered ko lahat ng kumpanya. La Tondenia, Nestle, Coca-Cola, lahat na yan. Taga-UB ang abogado dyan. No? Kanya, ang kanang taga-UB, ilang na ng daog-doogon, taga-UB. Ang mga tauhan ako, taga UP, taga Ateneo, pag nagwilga, if there's a strike in the head office, usarag yung katao manaog para mo atubang striker, taga Uber gyud ug kana mao si JBJ. Tubangon ako na mga striker. Sa may problema ninyo bay? Mga Bisaya man sa mga buang, mga striker. Na sir kami reklamo mi kay kanang usa ka sakong bigas ba sir kada buwan ihatag namo ang quality pareha man pagkaog baboy sa mami bigyan kami ng bigas tapos ang quality parang pagkain ng baboy. Sabi ko pasok kayo doon. Mag-usap tayo. Imbes na magsigaw-sigaw kayo dito, initan pa kayo. Punta kayo sa itaas, mga aircon doon, mag-usap tayo. Yun ang style ko. Kahit nung undersecretary ako, yung mga magpipikit dyan sa harap ng dole, sabi ng Secretary of Labor, bakit mo kausapin yan? Minumura tayo. Sabi ko, kaya tayo minumura dahil hindi natin kinakausap. Ako, kakausapin ko yan. No? Kasi kahit galit ang tao, basta harapin mo siya, pakinggan mo, kahit hindi mo sagutin, basta makinig ka lang. Mailabas niya yung kanyang sama ng loob. Itong pilot strike, ito sinabi ko na sa inyo ito sa ALPAP versus PAL. Dito talaga nalugi ang Philippine Airlines. Biro mo na mga pilot, yung mga eroplano dinala nila sa ibang bansa, dinala sa San Francisco, dinala sa Tokyo, sa Dubai, iniwan yung mga sasakyan doon sa Sydney, Australia, sa Kuala Lumpur, Malaysia, sa Taipei. Iniwan nila lahat. Yung mga international flight, iniwan nila. Tapos, iniwan na yung aeroplano doon. Umuwi na sila dito, sumakay ng ibang airline. Biro mo, si Mr. Losyutan, doon dumapa talaga. Sa ginawa ng mga pilot na yung ALPAP, Airline Pilot Association of the Philippines, ALPAP. That is the richest union in the whole Philippines. May 2 building yan sa Makati. Meron pang building sa Ayala, Alabang yan. Yaman ng union na yan. That is the richest union. Pero mo, pag ikaw pilot ka, ang sahod mo 450,000 a month. Yung union dues nila, 10%. Di 45,000 a month. Ibibigay doon sa union. Pag wilga nila, wala. Sila lahat, they lost their employment status, they forfeited their retirement pay, doon sila kahit ano pa nakarating Supreme Court. This case was a landmark decision where the state acting, kasi this is an airline, this is indispensable to national interest. You cannot just take this lightly. You have to take this seriously. A strike is illegal. A strike is if there is a collective bargaining agreement that includes a no strike clause. Alam mo, pag kami mag-negotiate ng collective bargaining agreement, pipirma yung union. The union agrees not to strike and management agrees not to lock out for the period of 5 years. Nakaroon yung no strike clause. Ang sabi ng Supreme Court, valid yan. Basta ang reason mo ay economic. Pero pag ni-union busting mo yan, if you subject the union to union busting, meaning you terminate yung mga official nila, even if there is a no strike clause, they can still strike because a strike is a weapon of self-defense. You remember what I told you? Unfair labor practice is a virus that attacks 3 rights, even 4. What are the rights that are attacked by the virus of ULP, unfair labor practice? Number 1, the right to self-organization. Number 2, the right to collective bargaining. Number 3, the right to a peaceful concerted action. And the right to security of tenure. This is being attacked by a virus. And since there is an unlawful aggression, which is the attack made by the management against the union through the ULP as a virus, the union now is given a self-defense, and that is the strike. The strike is a weapon of self-defense because, you know, if you remember your criminal law, what are the elements of self-defense? Number 1, there is an unlawful aggression, which is the ULP. Second, there was lack of sufficient provocation on the part of the person defending himself. And number 3, the means that he used to repel the aggression is reasonable. So, therefore, ladies and gentlemen, the right to strike is a weapon of self-defense. It is not a weapon of offense. A strike should not be used as an offensive weapon. It is a defensive weapon. You can only use the right to strike when there is an aggression from the employer. So in many cases, like in the case of the community hospital along Jones Avenue, they used the strike to compel the management of the hospital to recognize them as a union and to abandon the recognition of the incumbent union. They want to replace the incumbent union and they use the strike to do that. That is wrong. Because that strike was not a defensive strike. It was an offensive strike. So, di ba tayo sa ating constitution, Mr. Carion, sinabi doon, the state renounces war as an instrument of national policy. So what is being renounced is an offensive war. But if we are attacked, even if there is a provision of renouncing war, we have to defend ourselves. Therefore, the right to strike, since it is a defensive weapon, it becomes lawful to defend our rights if it is being attacked by an unlawful aggressor. See? Do you understand what I'm saying?
Yes, USEC, I understand.
Ayan, dito, sinabi ng Supreme Court, si Justice Bersamin ito, no back wages for strikers. Even if they were reinstated, because they are merely members, they are not entitled to a back wage. Why? It is your decision not to work. So why do you ask for pay? The principle is no work, no pay. Hindi naman kayo pinigilan magtrabaho, kayo na desisyon na ayaw magtrabaho, di magdusa kayo. Pero nung anak ko, nung maliit pa, sabi, Daddy, pag hindi mo ako bigyan ng magandang cellphone, maglumpasay ako. O di sinabi ko, sige, sinabi ko sa mga maid, alisin nyo yung mga furniture para maglumpasay yung anak ko. You give it to him. And then later on, siya na rin nasusurrender. So, yung mga striker, kung mag-strike sila, ginusto nila yan, huwag naman silang bumalik manghingi ng back wages. That is already killing the ghost that lays the golden egg. Protection to labor does not mean oppression and destruction of capital. There must be balance. Oh, see? So, it is 7:49. I have nothing more to say. And I think that I have delivered the message today. Today, the message is very clear. The right to strike is legitimate. But even legitimate rights should be done within the framework of the law. Your right to strike is not a license to violate the rights of the employer. You have to do your right within the bounds of the law. There is a right way to do the right thing. at the right time by the right party for the right reasons. So, with that, ladies and gentlemen, I rest my case. And we will take our picture. Take
Thank
our
you,
picture.
Attorney.